hello. I'm sure you see that we have a name change, right? So, welcome to another installment of the Empowered Esquire podcast. I have finally acknowledged that we are podcast style, right? So, hey, let's roll with it. All right. Hello to everyone in the chat. Hello to K Business. Hello to Mara Charisse. Long time no see. How are you? Hello to the beautiful Bernice, another long time no see. And everyone, check out K Business Podcast. He's been producing some wonderful entrepreneurship content for a while now. So yeah, give him some support, right? Let's show him some EE family love. So as you see from the name of this slash title of this video, we are going to be discussing a case in which some pro-life protesters slash activists were actually indicted for protesting. Now, we have to have this whole conversation before I bring on this guest, right? We are not discussing pro-life or pro-choice as in moral standpoint, right? We're not discussing pro-life or pro-choice as in personal opinion. And the reason that we're staying away from that for this video is because we need to discuss peaceful protest and whether or not our right to peaceful protest is being eroded by some of the current federal legislation. It's a serious conversation, right? And it's a conversation that I do not want clouded by our personal opinions, okay? So, with that being said, I'm going to bring on our guest. She is an activist. From everything that I've seen of her online, you know, I like to research my guests to a certain extent, right? From everything I've seen of her online, she is a mother, a wife, a minister at that, right? And so please do grant her love and respect like you do all of our other guests, right? And even if your opinions might be different from hers, please be respectful. Okay, so I'm going to bring her on now. Hello, welcome to the show.
Hi, thank you for having me.
Thank you so much for coming on. Would you like to introduce yourself to the EE podcast viewers?
Hi, EE podcast viewers. How y'all doing? I am Bevelyn Williams, formerly known as Bevelyn Beatty. And I'm just a strong Christian in the Lord, pushing as I'm supposed to in Christ. Yeah.
Yes, welcome. So as you heard, right, a minister, a follower of Christ. So again, be on your best behavior, everyone in the chat and everyone stopping by. So Mrs. Williams, could you tell us about the incident that has brought you here today? So to our knowledge, you were actually protesting against, or rather you were protesting in support of pro-life policies, and that led to your arrest.
Yeah, so right now I'm indicted. One is on conspiracy and another is on felony face act. They're saying that while I was standing by the door, someone's hand got caught in the door. Therefore, because they had injury, that would take up the charge to felony. And then conspiracy because me and my co-defendant conspired to be in front of that abortion clinic. And so do I get into the entire story, or how do you want me to start?
Yes, I would say go ahead and give us as much insight as you think. Listen, we have time. So, as much insight as you think necessary before I dive into the legal portion of this.
Okay, wonderful. So we had decided to do a rally, Jesus Matters rally, in front of the abortion clinic. Now, the way things work in New York is the sidewalks are public. It's not like an abortion clinic in like Atlanta or something, where they kind of have the whole parking lot and they kind of run it because that's their property. Basically, up until the door, everything is public property, right? So we decided to go to this protest. And now the thing is, because we have scheduled it and put it online, usually they know when we're going to have these protests. And so to avoid women that are actually coming in for abortion service to see us, what they'll do is schedule them really early in the morning, or won't schedule them that day. They usually will just, not have, certain women come. Now, they may be walk-ins, but like they'll, to keep the women from, I guess, feeling nervous or whatever like that. So they also book counter protesters to come and counter protest against us. So when we had gotten to the area, there were barricades placed by the door so that we could not cross, so that women could walk inside. And so we stood in the barricades, because we said, we're still on the sidewalk. We said these barricades are illegal. You can't put these on a public property like this. You don't have the right to do that. So they called the police. The police came. Now, in the meantime, the I guess the hired protesters had kind of gotten in front of the door and kind of stood behind me, and they kind of had umbrellas in front of me, and kind of that was their way of blocking us off with umbrellas. So the protesters had basically crowded around us and utilized umbrellas to block us from being able to talk to the girls inside of the barricades. The police came, and the police, at first they were like, you guys need to just go across the street. And we were like, listen, we're not going across the street. That's our right. We have every right to do that. Are not legal. We're going to remove them. So now, I believe once the barricades were removed, we no longer stood in front of the door, and everybody was able to kind of walk around. But because the higher protesters were able to stand at the barricades, though they were not scheduled volunteers, there's a difference. Volunteers that escort women in have on pink vests to let women know they work for the clinic and they're escorting them in. The protesters did not have that attire. They came specifically to protest. So the thing is, I never leaned against the door. I never touched the door, because I know that's their property and that would cause for me to get an arrest. So I never put my hands on the door, and I actually never got too close to the doorway to where I could completely block it, because there was protest. Their higher protesters were standing behind me. So I was standing in between the barricade, but not blocking the door. So the argument could be, oh, the protesters that they hired need to be charged just as well as us, whatever. So yeah, because of that, that's why they indicted me. And they said, I think it's fabricated, to be honest with you, because I don't touch the door. I know better. So it couldn't have been me blocking somebody's hand, but I believe that can go into other things. But yeah, so that's what happened.
Well, thank you for giving us that insight and that firsthand account of what happened. With a lot of these cases, especially cases that deal with sensitive topics or sensitive issues, what happens is that the quote unquote story, if you will, or the narrative is retold and retold and retold and then by the time it gets to the last person, it's kind of like the telephone game. By the time it gets to the last person, it is absolutely not what happened. So it is wonderful to hear from you what happened. Hello to Empress Goddess. I hope I'm saying your name correct. Empress Goddess Peach. So Mrs. Williams just gave us her firsthand account of what occurred during the protest that she was later on indicted for, right? And so now we can have the conversation about your rights to protest. So you may have heard that you have the right to assemble. You may have heard that you have the right to peacefully protest. That is not folklore. That is an actual thing, and it is in the Constitution, the US Constitution, that you have the right to assemble and you have the right to peaceful protest. And when you think about the United States of America and the way that we began to be who we are now, what we are now, protest and assembly was essential to that, right? Starting with the revolution against the British and coming into modern day. Even when you think about a lot of the movements that we've had, the civil rights movement and things like that, the right to assemble and the right to peacefully protest a law or practice that you don't agree with is how we became the country that we are today. And so the question that we're going to address today is whether or not it is constitutional for us to pick and choose which issues you cannot protest against, right? So it's not about what side you're on. It's, is it appropriate for us to decide what issues are open to protest? Is it appropriate for us to decide that there are some issues that you're just not, quote unquote, allowed to protest in regards to, right? So I have an article that has the actual indictment that was actually filed. It was initially sealed, but now it is unsealed, so we can look at it. And we're going to look at that indictment. But what we'll do first is take a look at the Constitution and some of the law that was quoted in regards to Mrs. Williams' prosecution. So let me first bring up, so we're going to congress.gov. If you're new here, you know that every single live when we discuss these cases, I bring up the actual law. I post and I share my screen and we look at the actual law. And the reason we do that is people do not read the law. I mean, and listen, I don't blame you. You know what I mean? Some people don't like to read. That's another conversation, right? But when we're having these conversations, you have to know the law. Okay. So let me share my screen here. Let's see. I always announce when I'm sharing my screen. I have no idea why. And so now you should see, let's see. Perfect. So now you see the Constitution annotated. This is literally congress.gov. This is the actual Constitution. Okay. So here we are in the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peacefully assemble and to petition the government for a redress of grievances. So let's take a pause there. Now, the government is not supposed to help you or assist you in practicing your religion. True. But the government is also not supposed to stop you or prevent you from practicing your religion. It's very important that you remember these things because as we discuss, laws and rights and all of these legalities, they do not exist in a vacuum. They all flow together. They all operate together, especially when you're talking about the US Constitution. So think of the Constitution and all of the federal statutes as like a car, right? They are one vehicle. They're not operating separately. So especially in a case such as Mrs. Williams' case, we are talking about a nexus of her rights to practice her religion, her freedom of speech, her right to assemble with others who share her religion, and her right to peacefully protest. So with the nexus of all of those rights combined, that's the lens through which you have to interpret this case, right? And as I said, thereby lead yourself to a conversation about whether or not your rights are in danger if these types of prosecutions are occurring. Okay. So there's a lot here about, your right to practice your religion and all of that, right? And I'm going to post the link to this in the chat so that you have this. But I really want to focus on the actual wording in the Constitution because quite frankly, that's enough. Okay. So as Mrs. Williams shared when she first came on, actually, I didn't ask her if she prefers Mrs. Williams or Bevelyn. Do you prefer Mrs. Williams or Bevelyn?
I mean, either or. I love my name all the way through. So Mrs. Williams, Bevelyn, whichever way.
Wonderful. I just want to give you the respect due because I need to let you know, and I'm glad that I didn't say this before we got on because it needs to be authentic. Kudos to you. Kudos to you for standing up for what you believe in. Whether or not people agree with that or not, it's rare nowadays that people stick to what they believe in and stand for that. So we want to give you your flowers for that, Mrs. Williams.
And I appreciate you. I really do. And I'll say, I don't want to be preachy, but I'll say this. If I came in confirmation of Bevelyn, girlfriend, I'd be at home taking care of my husband and my kid. But, I became a Christian and I became a Christian for real. And so for me, I have to serve him in spirit and truth, period.
Yes. And as I said, kudos to you and amen to that, right? I believe that whatever your beliefs are, whatever guides you, whatever your moral compass is, you should feel that you can represent that. And if people disagree with you, then they should be able to disagree with you in a respectful way. But it shouldn't be that you're not permitted to say things that other people don't agree with.
That's right.
So back to the Constitution, right? So being that we know that Mrs. Williams is Christian, right? We know that in the Christian religion, there is a religious text, right? That is the Bible. Now, some people argue that the Bible doesn't necessarily address pregnancy termination. I've heard that argument. It's a thing. But I think if you've done a little bit of your own reading, right, you'll see that the religious text of Christianity, the Bible, it mentions the taking of life. Okay. So you can get scientific as to what is life, what isn't life, right? But the religious text has an establishment for the religion being against the taking of another life. So this is how you have her freedom to practice her religion being implemented here. Okay. Because her religion says you should not terminate life, right? And many believe that a child in the womb is life. Now, there are some who believe that isn't life yet. Again, that's a conversation we're not getting into. We're just establishing what rights are at play here. Okay, so first we talk about that. Then we talk about freedom of speech. Okay, so now we have another moving part here. So we often hear people having the back and forth about pro-life and pro-choice, right? It happens on the internet, it happens in person, it happens on the sidewalk, it happens in cafes, it happens at offices, at family gatherings. It is your freedom of speech. It is absolutely your freedom of speech to address and to express whether you are pro-life or pro-choice. That is absolute. The only things that should limit your freedom of speech are things that are quote unquote harmful to another person. Now, I want you to keep these things in mind, right? Because you're going to find that as society, I want to say progresses, right? I'm going to use the nice word. You'll come to find that as society progresses, a lot of these boundaries begin to expand. So initially, your freedom of speech is only limited by harmful speech, right? Speech that would incite the harm of someone else. That used to be that said speech would have to be, discriminatory in some manner, or that it would have to directly invoke violence. That is what used to be the restriction on freedom of speech. In modern years, that restriction does seem to be expanding. Okay, so then the next right now, the right of the people to peacefully assemble. So Mrs. Williams was not by herself, right? She was also not indicted on her own. And so what she did in her act of protest was also the assembly with others who also have her same beliefs and have her same opinion in regards to pro-life versus pro-choice. So now you have this infringement on whether or not you are permitted to assemble with others who believe what you believe, and where are you permitted to have that assembly. And then the last right that we mentioned, well, we're not going to go there, petition the government for, well, actually, we could. So this argument is a bit more tenuous, but there is the right to petition the government for a redress of grievances. Again, this is the more tenuous argument in regards to the rights to protest. But the argument does exist to say that if your government, if your either local legislature, state legislature, or federal legislature is passing laws that are quote unquote pro-choice, while you are pro-life, right? The argument can be made that you are even protesting your government in a way, right? You're asking your government to redress your grievance in regards to the laws that they are passing that are against what you believe. Okay. So now we've established that according to the firsthand account provided by Mrs. Williams, there are several First Amendment rights that are implicated by the case at hand, right? Now we've addressed that. Now, my question for everyone in the chat is this. Mrs. Williams mentioned that she was there protesting, yes, but that very often there were also counter protesters there. So my question for everyone in the chat is, do you think that it is legally sound that Mrs. Williams was arrested as well as her fellow pro-life protester, but that there hasn't been any arrest of any of the counter protesters that were present? I'll say give me a 1 in the chat if you feel that no, Mrs. Williams may have crossed the line by going past the barricade or whatever your opinion is, right? And so her arrest was appropriate. Or give me a 2 in the chat if you feel no, if protesters from both sides are present and anyone is being arrested, both sides should have been arrested. I will give you all a moment to think about that while I have a sip of water.
That's a great question, by the way.
Thank you very much, Mrs. Williams. I'd like to kind of peer into the mindset regarding, as I said, the right to protest in regards to people who you do not agree with, right? That's kind of what I'm trying to get to the heart of. It's we all have the right to express what we feel and what we believe, but it is human nature that we feel that right, more so strongly when we agree with the person. So I'm really trying to get to the heart of, do you believe that these rights apply to people who may not agree with you? So, a one in the chat if you feel that no, Mrs. Williams totally crossed the line by having a pro life protest at a clinic where women receive services that terminate pregnancy, or a two in the chat if you feel, well, if counter protesters were also allowed to be there, then counter protesters should have also been arrested. And while we do that, I'm going to bring up the actual indictment, which I'm getting via Fox News because, as I said, they posted it since it is now no longer sealed. And then you guys know I love to walk through these legal documents with you, explain them to you, and have that conversation. Should I stop? Well, I don't have to stop sharing my screen. I can just let it. Okay, so Mara Cherise says, no one should have been arrested. I'm still trying to understand why she was arrested. Well, Mara, we are going to look at the actual indictment. Let's get into that.
And technically, we weren't arrested. We never got arrested. They indicted us. This was in 2020.
Mm-hmm. And so they indicted you, but have you been arraigned? Have you been?
Yes. So we were arraigned December 16th.
Okay.
Yes. Oh, so maybe that's what she means by arrest. But on the day of, which was in
Mm-hmm.
2020, we were not arrested.
Okay, then. So good. That's some good clarification for anyone who might be confused. So they were indicted. Now, remember how indictment works, everyone, right? It usually, now, and I say usually because there's always some caveat, but usually with an indictment, it is not an arrest in that sense. The person is first indicted, meaning the evidence against that person is brought to a grand jury. The grand jury then votes whether or not to indict that person. And from the indictment, an arrest warrant results. Right. So what happened in Mrs. Williams' instance is not that she was arrested that day, but rather that she was arrested after an indictment was actually returned. All right, good. So here we are looking at her actual indictment. Can everyone see it? I wonder if I can make this larger. Maybe I should have downloaded it. I didn't think of that. Oh, yes, I can zoom in. Wonderful. All right. So for people who have been with me for a while, right, I like to call you my OGs. You understand what we're looking at here. But for someone who is new, I will walk through it in a way that I may not usually, right? So at the top of this document here, this is the case caption. The minute you see United States of America, you know that you are in federal court. So this is not a state prosecution. The United States of America, i.e., the federal government, issued this indictment. So here we have the defendants are Bevelyn Betty Williams and Edmay. I think I said her name right? And I don't want to Siobhan. Thank you, because I don't want to butcher her last name. So Bevelyn Betty Williams and Edmay Siobhan. Okay, sealed indictment, which is now obviously no longer sealed. Count one: conspiracy to violate the freedom of access to clinic entrance. Okay. So remember, when we talked about Shanquella Robinson, we talked about conspiracy, right? And we talked about conspiracy being what? More than one person coming together to quote unquote conspire or to make a plan to break a certain law. That is literally what conspiracy means. So that is what is being alleged here. Okay. So Bevelyn Betty Williams and Edmay Siobhan, the defendants, are the founders of At the Well Ministries. Okay, a nonprofit organization started in 2014. Okay. Williams and Siobhan, individually and at times through At the Well Ministries, have sought to prevent lawful abortions from occurring throughout the country. Interesting. So what we have here, again, remember when we're discussing your right to practice your religion, remember that in accordance with the religious text that is central to Christianity, right, The pro-life movement is intricate to that because the actual wording in the religious text is against the taking of life. So the fact that having a ministry and then through that ministry talking about your religion, talking about your beliefs, and protesting in accordance with those beliefs is being referred to as preventing lawful abortions.
Yes. You see how slick they are with their wording?
That's very interesting, right? That's a very very interesting way of phrasing that, right? Because in reality what's happening is a ministry that is stemming from Christianity is professing the beliefs of Christianity. That's thus far what we've heard. And listen, when we do these lives, I don't come on here in a biased way, right? So what I just said to you is a fact. Not at all biased, not at all my opinion, right? Literally, this is a nonprofit that is a ministry, and then when they go out, they discuss the ministry. That's what is happening. So very interesting. So then the indictment goes on to say that from 2019 up until 2022, Mrs. Williams and Edme Siobhan, the defendants, agreed to and engaged in unlawful means in the aid of their goal, which is to prevent lawful abortions, allegedly. In fact, Williams and Siobhan repeatedly agreed to and did use unlawful means, including force, threats of force, and physical obstruction. Interesting. To injure, intimidate, and interfere with individuals seeking to obtain lawful reproductive health services and individuals providing such services. Now, let's stop there, right? Because that was a lot of legalese. And when we look at the FACE Act itself, you will see that that is the wording, that's the literal wording from the law. Very often when we discuss these prosecuting documents, I tell you that the prosecution has the burden of proof. So they have to use the wording of the law that they are using to prosecute the person, because they literally have to prove that the violation of that law occurred. And they have to prove that beyond a reasonable doubt, which we've discussed, what beyond a reasonable doubt means. And sadly, there is no, one definition for that. But as we've very often discussed, the best way that I have ever heard beyond a reasonable doubt explained is this: the prosecution has the burden of proving that there is no other practical or reasonable interpretation or version of events. That the only answer is that this law existed, that this law was broken in this manner. That is beyond a reasonable doubt. And it is a very high burden. It sounds like it's a high burden because it is. So now a question for Mrs. Williams. And I will say, Mrs. Williams, before you answer this question, of course, if you have been advised by your attorney not to speak on anything or not to answer a certain question, that is totally fine. Okay. My question for you is, here we have this allegation of force, threats of force, and physical obstruction. To your knowledge, did any of that occur?
Well, I and Edme are 100% anti-violent. Okay. Have we been threatened by, women going in or, pushed? Absolutely. But as far as us taking a stand of forcing ourselves, pushing people, violence, no, we have never, ever. And as I've said before, with the felony of someone's hand getting caught in the door, because that's the best they could use, that will fall because, again, I don't touch the door because I know the moment I touch that door, all right, I'm getting arrested. But now you have counter protesters. This is the thing. When you're in a protest and you're in the heat of the protest and protesters are coming, they have no problem getting in your face. They have no problem pushing you and nudging you. Okay. But if you fall away with that, then fine, they won't bother you. But if you stand your ground and you're not allowing that bullyism to push you, it's like, oh wait, you're violent. You're violent because you're not letting me push you to the floor. So as far as us putting our hands on anybody, hitting anybody, I've been doing, every time we go out in protest, we're always on camera. Always on camera. I've been hit, I've been pushed, and I always say, hey, back it off. We don't do violence. Anyone who knows me and knows my following, no, I don't do violence. I got stabbed, okay? But still, I don't do violence.
And so this allegation that is in the indictment, as I said, it comes along with the beyond a reasonable doubt burden of proof. Now, the indictment then goes on to allege that there was alleged attempts to intimidate and interfere with individuals seeking to obtain services. So here's the thing about that. Wording such as intimidate, wording such as interfere, that type of wording in a statute is dangerous. And I know we've had discussions
Yes,
about
it
law
is.
before. Yes. And I know we've had discussions about law before, in which I tell you, when you're reading law, you have to be mindful of the terms that are used, right? Law should have objective terms. I believe, again, this is just my opinion, that law should have terms that are as objective as possible. Because if the law has terms that are vague, that are broad, that are subjective, then you enter this realm of uncertainty. Now, what sometimes happens in this country is that you have laws that are vague, that are broad, and then we have cases, quote unquote, case law, that then specifies what is what. And as you all know, my personal opinion is that that is dangerous, right? My personal opinion is that laws should be written in a manner which allows for them to be construed and interpreted in a more so strict way, right? That doesn't necessarily allow for all of this interpretation. So when you use a term like intimidate, well, now you have to ask yourself, well, what is intimidation? Because, for example, Felicia might be intimidated by someone like waving a marshmallow at me. But Mrs. Williams might not be intimidated until you pull out a weapon. So what is intimidation? Then you talk about the term interfere. Well, what rises to the level of interference? Is it interference if I stand outside of this clinic or building and I say that I am pro-life? Is just me being there interference? Or do I have to do something physical to someone? And now we've rise to the level of interference. What exactly is that? And when we go to look at the FACE Act, you will see that using these terms in law can be really dangerous. I'm going to concede the floor to Mrs. Williams because I have the feeling that she's got a lot to say about that.
Yes. For me, it's like you said, when we are going in, we got to stay subjective, right? We can't go into a place where it's just based off of your feelings and oh, I feel intimidated. I can say right now, this interview is intimidating me, so I want to press charges on you. It doesn't make sense. It really pushes smoke and mirrors, and it gives this vague situation, but there's no direct. I'm standing outside. They're inside doing these abortions inside of whatever surgical building or surgical room that they're in. uh Me standing outside interferes with them. I don't that You cannot prove that. That's all opinion.
And so what it really lends to in regards to, as I said, interpretation, it lends to, well, does someone have the right to do whatever it is they want without having to hear anyone's opinion about it? That's kind of at the heart of what we're discussing, right?
That's basically it. You hit the nail on the head.
Do
You
you
hit the
have
nail
the
on the
right
head.
to do whatever it is you want without hearing anyone's opinion about it?
Yes, because now the thing is, the issue now is the claim. You don't have a right to tell me what I can and can't do. That's where we're at with this.
And again, in general, you might say, yes, I believe I have the right to do whatever. But remember, you have the freedom of religion. You have the freedom to practice that religion. So all of these things are encompassed, right, under the right to practice your religion. If your religion expressly says, let me break it down to a more even simpler level. Let's say your religion expressly says, it is immoral for people to live in buildings that are multi-unit because they're on top of each other, and that is unhealthy. And so people should only live in one family buildings. Let's say that your religion said that, right? And I'm using a really out there example to let the point hit home. So now this person decides to go to the middle of Manhattan where there are tons of large buildings and tons of people living, on top of each other, and stand on the sidewalk and say, this is against my religion. I don't think it's appropriate that these people are living this way. The question is, do the people living in that building have the right to tell that person, oh, I don't want to see you. I don't want to hear your opinion because I don't like that opinion, or because that opinion doesn't allow me to live the way that I want to? And I think when put in simpler terms like that, it might hit a little different. Okay, so I'm going to go back to.
Could I
Go ahead.
answer that in my own way? For me, I feel like, yeah, they have the right to go up to you and tell you that, but they don't have the right to move you from where you're standing. They don't have the right to hinder or hinder your expression of how you feel. They can tell you all day and night, hey, I don't like the fact that you're standing in front of my building. I think you should leave. But it begins and ends there.
Right. And so from a legal perspective, according to the Constitution, you should have the right to say, I do not agree with persons living this way. Again, it doesn't mean you harm them. It doesn't mean you threaten them. But constitutionally, especially when we talk about the right to exercise your religion, you should have the right to say that you do not agree with it. Now, as we move further into the indictment, there is something that gets even more curious. So here in paragraph 3, it says, from at least in or about 2019, up to and including in or about 2021, Bevelyn Betty Williams and Edme Siobhan regularly protested in front of a healthcare provider located in Lower Manhattan. Let's stop there. So if you've been here for a while, as I call you my OGs, the minute that you hear from 2019 to 2021, you already know what's happening, right? But for some of the newbies, allow me to enlighten you. So very often in federal prosecutions, because the federal government does things very methodically, right? So very often in federal prosecutions, you will see that there is this lengthy time. There's from 2000 to 2020, right? And the purpose is to establish a pattern. It's to establish a pattern of behavior. This is why they use time periods that are so long, and they take multiple instances and try to pin them together, right? To establish a pattern. But there's something even bigger than that. So, and we talked about this as well when we talked about the Bill Cosby prosecution and the R. Kelly prosecution, because of the years that had elapsed there, right? So first, they establish a pattern when they talk about these multiple instances, but there's something important about that pattern. That pattern allows them to discuss things that they would not usually be able to discuss. So remember, according to the federal rules of evidence, which here's a little random tidbit that I think I might have told y'all before, evidence was my favorite class in law school. I don't know why. So according to the FRE, you usually cannot use someone's past against them. Usually, if someone has an arrest that didn't result in a conviction, you're limited on how much you can use that. Usually, if someone has past behavior that never actually resulted in any legal issues, you're limited in which you can use that. Usually, prosecution is very limited in their ability to use a defendant's past against them in current prosecution. But when you establish a pattern of behavior, meaning you take multiple instances over a length of time and you say the same behavior happened in all these instances, right? Once you establish a pattern, you're now able to go into that person's past, pick any incident that fits the pattern and use it against them. You're now able to talk about that person's past as their quote unquote modus operandi, right? Their mode of operating, and use it against them in court. So we see that the pattern of behavior is being established here, allegedly, right, through these allegations. It's the reason that you have 2019 to 2021, because it's likely that the prosecution may be trying to dig even further than that and use a pattern of behavior. So then they go on to specific events of protest. They talk about June 2020, and they name some specific dates in which they say that Mrs. Williams and Edme Siobhan were at this health center physically protesting. Now, this is where it gets interesting. So it says at the very end of this page, Williams and Siobhan threatened and used force against health center patients and staff members and blocked access to the health center. Now, again, I will say to Mrs. Williams, if you've been advised not to answer this sort of question by your attorney, that is fine. The question is, do you believe that anything occurred while you were present that meets the level of this allegation?
Well, I find it so interesting. We put this event on Eventbrite and we still have it. And what we say is, we declare war on Planned Parenthood, right? And then right under it, we put in bold letters. This is a non-violent, non-profanity event for Christians only. Okay? And so, which I had to dig up all of this stuff because I had totally forgot. And so, again, as I said before, everything we do is recorded. Everything is on camera, you know? So being in front of the clinic, you know, standing with people, they may push you, they may nudge you, but fighting and pushing and threatening and keeping patients from coming, no. And like I said before, when they know that there is going to be an event, they purposefully make sure they don't schedule women to come in, and they only have their volunteers come and their hired or maybe even volunteer counter protesters.
And so, again, bearing in mind what we've discussed about your right to practice your religion, right, it's important to note things such as this was an event that was publicized within the Christian community. This was an event that was publicized as an opportunity for Christians to publicly voice their religious belief. It is very important that you note that, because, again, the conversation we're having here, and I mean, from the depths of my heart, hope that people are able to do this. Separate your personal opinion from what is happening. Because if we cannot separate our personal opinion, so for example, if we allow our right to protest to be rolled back and rolled back and rolled back because we don't want protests about things that we like, we're in dangerous waters. Because then you can't protest something that you agree with, right? So now the event was promoted as an event for Christians to publicly express their Christian beliefs in public, on a public sidewalk. Okay, so let's move on with the indictment. So we are here on what page? Page 3 now. Now, here it says, or it alleges, that on or about June 2020, Williams, which is our guest, live streamed a video onto Facebook. The allegation is that Mrs. Williams said that it's going to be a wonderful day and that they are going to, quote unquote, terrorize the place. The indictment then went on to allege, or goes on to allege, I should say, that while Mrs. Williams said this, she was in close range to a health center staff member. Now, remember the burden of proof that is required, right? So these allegations have to line up with the burden of proof. And quite frankly, this allegation lines up with the law that we heard in the beginning. So now, as I've been saying before I ask these questions, Mrs. Williams, if you've been advised not to answer this kind of question, we understand. But the question is, to your knowledge, did the language of terrorizing the center actually occur? Is that accurate? And were any of the pro-life protesters in close range with the employees?
That is true. Yes, I did say that 100%. And what you say that last question one more time.
And were any of the pro-life protesters in close range of the health center workers?
No, actually, we were standing when I said that, we were standing already outside of the place, and I was on the sidewalk. and I'm talking and I'm letting people know, come on, we're gonna terrorize this place. We're gonna let them know Christians are here. We're gonna be loud. We're gonna preach this gospel. No one's getting no peace. No peace. We're gonna be loud about this. So yes, I did say that, and I think I was standing away from somebody when I said it. We don't get close to them because we know that they can accuse us and we can get charged. It is so easy for a pro-lifer to get charged because I believe the police see us as the and this is just my opinion, they see us, we're making them do more work. We're the ones going to protest an issue. We're the ones giving them more work. So we're the antagonizers. So I mean, we blow wrong and we're locked up, so we have to be very strategic about how we move, or we will go to jail. So no, none of our people got close into the workers' faces, put our hands on them, nothing other than the counter protesters nudging us, pushing us out the way, that, or putting their umbrellas in our face. That's it. And that's all on camera.
So now it's interesting when we talk about subjective versus objective and the use of the word terrorize, right? Because yet again, this could apply differently to a different person. So for some person, someone may say, well, I feel intimidated or I feel threatened by someone using the word terrorize towards me. But another person might say, well, I don't feel intimidated or I don't feel threatened unless there is action that comes along with the word terrorize, right? So again, what rises to the level of this statute is unclear as of now. So let's move on a bit further, right? We see again, they say at various times on June 19th and June 20th, again, it looks like an attempt to establish a pattern. They then have an allegation that Williams and Siobhan moved in front of the staff entrance. Now, remember that the law, the FACE Act, right, if you will, it allegedly prohibits interfering with someone's ability to obtain services. Now, a strict interpretation of that wouldn't necessarily apply to employees, right? But again, that's a strict interpretation. If you use the more the more liberal, right, interpretation, if you will, and by liberal I don't mean politically liberal. By liberal I mean like as in loose, right? If you use a looser interpretation, one could argue that even quote unquote interference with staff equates to an interference with the health center. And again, we have the implication of your right to protest there. Because if you cannot do anything or say anything that allegedly interferes with staff or that allegedly interferes with outside operations, right? Then can you truly enact your right to protest outside of the center, even if you're on public sidewalk, right? Because it can be argued, again, when we go to subjective versus objective, that simply you standing there interferes with an employee coming to work. Because let's say they just don't want to have to walk by you, or let's say they don't like what you're saying, right? So this broadening of what applies when it comes to interfering with the operation of the center can also be seen as something that tends to back up against your right to protest, right? So now, Mrs. Williams, do you believe that there were any actions or any steps taken that interfered with the staff's ability to do their job at the center?
No, ma'am. Every staff member was able to walk in that door and walk out of that door. And they unfortunately had to walk through people preaching the gospel to them and warning them that they were playing a part in something that we believed is wicked. And as far as them getting into work and coming out of work, everyone who wanted to get in that building got in that building. And everybody who wanted to come out of that building came out of that building, period.
So again, we have our initial question, right? The question is, do you have the right to protest and express your opinion, even if others don't agree with that opinion? And according to the Constitution, you do, right? According to the Constitution, you do have the right to express an opinion that others might not want to hear. And so it appears that with the FACE Act and with some of these prosecutions in regards to the pro-life, pro-choice debate, it appears that there might be an effort to quiet down a certain side of the argument. And I alert people on both sides of the argument that that's dangerous, because it means that if it happens to that group of people, it could one day happen to you.
That's a fact.
Right. And that's the more mature point that I try to make here, and that I hope comes across to everyone. So the indictment then goes on to allege that Mrs. Williams pressed her body against the door of the patient entrance. We've already heard Mrs. Williams express that she did not touch the door, right? That is what she is saying. The indictment is alleging otherwise. So I say that just in the interest of, as I said, remaining neutral on that. The indictment then mentions quote unquote victims, which they say were actually harmed by Mrs. Williams' presence. We know that Mrs. Williams has already stated that she was not near the door. So again, you have the indictment, which it offers its own version of events and allegations, and then you have Mrs. Williams' version of events. So we don't even need to go into that, right? Now, here we have a statement, an alleged statement from Mrs. Williams, in which she supposedly goes on live stream and she says, we're going to stand here and we're not moving. We're standing here. And she said, so I guess, no women will be coming in for services today. It's a war zone. Now, let me address this statement let's confirm this statement before I address it from a legal perspective. Mrs. Williams, is that an accurate statement? Did you make that statement?
That's right.
So now let's address this statement again from the legal perspective of your First Amendment constitutional rights. We're going to stand here and we're not moving. Well, yeah, you can stand on a public sidewalk and decide. In fact, think about like the homeless population, right? You can stand on a public sidewalk. Now that's another conversation as far as the homeless population. Actually, I withdraw that statement because it is actually becoming illegal to be homeless. That's another conversation. Okay. But in theory, in regards to your constitutional rights, you can stand on a public sidewalk. So if Mrs. Williams decided to stand there and not move, that again falls under her right to assemble with persons who share her opinion, her right to express and practice her religion. Now, her statement that she guesses that no women will be coming in for services today, she literally says, I guess. So she's guessing. And remember, she's expressed that to her knowledge, when it is publicly professed that these protests will occur, the center allegedly did not schedule persons for services. That's just her belief, right? But again, she has the right to publicly protest. If the center chooses, if they choose, notice I said choose, not to schedule persons for services because Mrs. Williams will be protesting that day, is that an implication on Mrs. Williams' part? Let me ask everyone in the chat. Give me a 1 in the chat if you think that Mrs. Williams is implicated by the center choosing not to schedule women on days that she protests. Give me a 2 in the chat if you think, well, that's a decision on behalf of the center and Mrs. Williams should still be permitted to exercise her First Amendment. So a 1 in the chat if you think, well, no, she's somehow implicated by the center choosing not to schedule persons that day. And remember, Mrs. Williams expressed that these events are publicly promoted. She goes onto Eventbrite or Facebook or wherever, and she lets other Christians know that she will be protesting. So it's shared publicly. So it's a 1 in the chat if you think, no, somehow she's implicated by the center choosing to cancel or not to schedule services, right? Or a 2 in the chat if you think, well, actually, that's a decision on behalf of the center and shouldn't limit the right for certain persons to protest. I mean, I'm sure we know what Mrs. Williams thinks. I think that should be pretty clear, right?
Yes.
I'd like to get to the heart of what we think, because again, this is the conversation about what is interference. What is interference? If someone chooses to publicly protest and in response, a center chooses not to offer services on the days of that protest, Does that rise to the level of interference? So I'm curious to know what you think. A 1 in the chat if you think no, you publicly protest, you can choose to publicly protest. Or I may have changed that around. Well, a 1 in the chat if you think that Mrs. Williams is implicated by choosing to publicly protest on certain days, right? Or a 2 in the chat if you think, no, actually, that's her right. And the center is choosing not to provide services on that day. Mm-hmm. So, as everyone kind of, I guess, comes around to your decision on that, we're going to move forward in the indictment, and I'll come back to addressing legally what applies there. So, in or about January 2022, Williams and Siobhan traveled to and were present outside of a reproductive health center in Fort Myers, Florida. Okay. Now they go on to allege that Williams and Siobhan directed other individuals to block the health center entrances. So the important thing to remember about a lot of the wording in this section is if person A tells person B, right, to do whatever, under federal law, first of all, that creates another chain link in the quote unquote conspiracy. And second of all, that creates a link in culpability. So the reason that that wording is used in that allegation is because the allegation is that Mrs. Williams and Edmé Siobhan should then be responsible for the people that allegedly stood in front of the entrance, right? So now the question boils down to, what was the purpose of the Fort Myers, Florida assembly? And also, was there anyone blocking the entrance? So, Mrs. Williams, as I've always said, if you've been advised not to answer this question, or if you feel that this question isn't appropriate for you to answer, you do not have to. But the question is, to your knowledge, was anyone instructed to block entrances? And what was the purpose of this assembly in Fort Myers?
This assembly in Fort Myers was an OSA event, which is a separate organization that we go out and do ministry with. I actually was pregnant at the time. I was visiting a mom and pop in faith. They had invited us to an event that they themselves had planned. We came to the event. So we did not plan the event. My husband was at the hotel working, and me and Emmy went and recorded the event. And I remember saying, dang, if I wasn't pregnant, I would have been laying on that door too. But unfortunately, that was not our event. So that is completely false.
So let's move forward in the indictment. Now, we see an instance in Nashville, Tennessee, which is in July in 2022. The allegation here is that Mrs. Williams and Edmé Siobhan were filming a video. Oh, excuse me. They entered the health center falsely purporting to be seeking services. And then Mrs. Williams and I guess Ms. Siobhan at some point admitted they were not seeking services. And at that point, there were some statements made about wanting to be let in or wanting to, quote unquote, take the building down. Now, let me say this before we confirm or deny this statement. So if someone enters a certain building or a certain place, and they initially say they enter that building or that place for a certain reason, and then that reason then shifts or changes, or the person admits that that reason is not accurate, what will usually happen at this point is that the owner of that premises, the what's the word I'm looking for? Not facilitator. We'll say owner. The owner or manager of that premises will then say to the person, well, being that you're not here to receive services, we are now asking you to leave. This portion is very important. The portion where the owner or manager asks the person to leave is essential, because theoretically, if the person is not asked to leave, then they are not illegally on that property. Because remember, when they entered that property, they said they entered to receive services. So now, with that being said, Mrs. Williams, did it actually occur? And again, do not answer this if you've been advised not to, or if you feel you shouldn't. Um, did it actually occur that you entered the center in Nashville saying that you wanted to receive services, and then later on withdrew that statement?
So yes, we entered saying that we would like to receive services. We never went into the facility. We were on the parking lot. And then he let us enter. We got out the car. We went to the front door and we said, we're going to pray this building down in the name of Jesus. And then eventually the cops came and made us leave the property. So we left the property. And then even after leaving the property, the cops still arrested us for trespassing, though we were not told to leave the property until the cops came.
Mm-hmm. So again, remember the initial statement that I made, everyone. The reason that the law applies the way that it does is because you can't read someone's mind. So let me give you a simpler example. Let's say that Vivian drives to a health center because she says she'd like to terminate her pregnancy. She parks, again, according to Mrs. Williams, she was in the parking lot, right? She parks, she's in the parking lot, and then she goes over to the building and decides, you know what? I'm not going to receive services today, right? There is no way for us to know whether or not she had genuine intentions from the beginning. So the idea that you're not permitted to later on change your mind isn't legally sound. Now, the second instance of it, when I said the trespassing portion, right? Yes, you are trespassing on someone's property if you are not welcome there and the person says to you, you are not welcome. This is private property. I would like you to leave. But now, if someone does not ask you to leave, and this building is offering publicly accessible services, right? And that's a caveat that a lot of people don't know. Your home is not like a health center. A person that is in your home when you didn't invite them, that's simple, right? But a health center is open to the public. So in that instance, if someone does not say to you, hey, you are trespassing, I would like you to leave, they don't say anything to you. But then later on, you are arrested for allegedly illegally being on that property, right? You can see how, again, you have an infringement of your right to be out in public. That you're out in public, according to what we are hearing. Because remember, the indictment has different allegations, right? The allegations that are spelled out in the indictment are different from what Mrs. Williams is saying. Okay. Mrs. Williams, do you have anything to add to that?
No, I think that's pretty much clear. I think, girl, as I'm listening to you, I'm thinking to myself, okay, so I feel like I should have never settled the case, which I know you'll get into in New York. And I feel like even with the one in Tennessee, I should have never just pled it. Oh, girl, I just feel so stupid right now because the way you breaking this down, I was just advised by some court-appointed lawyer, just take guilty and just take a fine. And I'm realizing, you know what? I should have fought a little bit more, but yeah.
I mean, the thing about, and I want to kind of, I guess, give a little bit of insight into attorneys who encourage to settle and plea and things like, here's the thing. Court can be unpredictable. And I think that's why a lot of attorneys just kind of advise their client, oh, just settle, or, don't take it to trial, because they fear the unpredictability. I think that's really what plays into it. There are instances where, the judge has a stomach ache that day. Now, is it fair that would affect you? No, but it could. It could literally be that your judge has a stomach ache that day and he's going to rush through your trial that day because his stomach hurts, And so little things like that scare attorneys because they fear that they cannot control everything that could happen. And that is what very often leads them to recommending to their clients, please just settle, because we can't control what could happen. So it's sad because, there are some things that you really should take up the mantle for. But just to kind of explain their mindset a bit, I think it comes from the fact that court is unpredictable.
Okay.
Yeah, I think that's where that comes from, because you can never predict what happens in court. It's absolutely unpredictable, especially if you have a jury. Oh my goodness, juries are extremely unpredictable. Um, so now getting back into the indictment. So again, and as you can see here, there are several instances. Remember the attempt to establish a pattern, because the pattern allows for the reaching back into the person's past. The pattern allows for the discussion of past, quote unquote, bad conduct, even if that person was never arrested, even if that conduct was never confirmed, right? So you'll see very often these long stretches of time, as we've discussed, to establish pattern of behavior. That's kind of like a red flag of, uh-oh, they're attempting to establish a pattern here. And it also plays into the allegation of conspiracy as well, because conspiracy allegations should have some, and I think we've discussed this before, but just in case we haven't, if someone is being accused of conspiracy, it is not enough to just say they thought about doing something with someone. There has to be some sort of action taken towards that conspiracy. So a lot of the instances that we see mentioned here as well are also the prosecution's attempt at proving that the conspiracy was somehow acted upon, that it wasn't just a bunch of words. So now they get into the statutory allegations. So what I think we will do next is pull up the actual law. It's called the FACE Act, to give it like a cute name, because they like to give all of these laws that people would not usually read cute names in hopes that you'll care about it. So it's technically called the Freedom of Access. There we go. Freedom of Access to Clinic Entrances. That's the technical name. If you're an OG here, we always go to not just the LLI, but we go to the LII a lot for laws. Okay, so this is the actual law. So this law talks about activities that are prohibited because they allegedly obstruct a person's freedom to access a clinic. Now, here is where, if you're a nerd like me, this is going to get really good. So remember, we talked about the First Amendment right to practice your religion and to assemble and to peacefully protest. But remember that all of your rights have limits and exceptions. And they have these limits and they have these exceptions under a certain area of governmental authority. One of those areas of authority is public welfare. So when you hear the language of access to a clinic, you know that the government is trying to insinuate that, hey, we can do this because we feel that you are limiting someone's right to preserve their own health. And that implicates our power to protect public welfare. Now, whether or not that implication would hold up in a criminal prosecution, right, that's yet to be seen. But we know that that's the implication here. So Section A1, they then say if by force or by threat or by physical obstruction, sounds familiar, right? Remember, this is in the indictment. Intentionally injures, intimidates, or interferes with attempts to injure, intimidate, or interfere with any person because that person is or has been, or in order to intimidate such person or any other person or any class of persons, from obtaining or providing reproductive health services. Notice the words that are being used. Notice that the FACE Act does not say pregnancy termination. Notice that the FACE Act does not say abortion. That's for a reason. It says reproductive health services because actions that involve pregnancy termination, actions that involve abortion, implicates the religious discussion, which triggers the right to practice your religion. That is the reason that they don't just say abortion here. That is the reason that they cannot say that you cannot protest against abortion.
Interesting. I got a question.
Yes.
So is that kind of contradictory to the fact that they mentioned abortion in my indictment?
It could be, right? But then they're hearkening back to this law, and this law says reproductive health services. So, you could get into a tomato argument there, because they could say, well, we use this word, but we're citing the statute, and the statute uses that word. The statute is really what's important.
Okay, makes sense.
Right. So it's important to note that the statute uses that word. There is a reason that the statute uses
I'm
those
going to take out
words
some point and wash.
as opposed to abortion or pregnancy termination. Now, it's also important to note that the statute says or attempts to. Again, remember, we discussed that intimidation and interference can be very subjective. So now the law gets even broader because the person does not even have to feel intimidated or interfered with in an active manner, right? It just has to be that they feel that the person tried to intimidate or interfere with them, excuse me. That is pretty broad. Okay. So Section 2 now. Section 2 says, by force or threat of force or by physical obstruction, intentionally injures, intimidates, or interferes with, or attempts to injure, intimidate, or interfere with any person lawfully exercising or seeking to exercise the First Amendment right of religious freedom at a place of religious worship. Again, the words are important. If that last portion, this portion here, at a place of religious worship, wasn't there, section number 2 would mean something totally different. Notice that if that last portion was not there, section number 2 would confirm the right of persons like Mrs. Williams to protest. It would confirm their right. But the addition of that last phrase there pretty much means, oh, you can't intimidate someone who is practicing Christianity at church. Or you can't intimidate someone who is practicing Islam at a mosque. Or you cannot intimidate someone, and I might be wrong on this one, please forgive me if I am, but you cannot intimidate someone who is practicing Judaism at their temple. I mean, that is obvious, right? So more than likely, what we have here with Section 2 is politics. More than likely, in order to get this law to actually become law, because remember, law has to go through the legislative process. So more than likely, both sides of the aisle were going back and forth on this federal law, and the compromise was Section 2. But Section 2 is honestly really, it doesn't even mean anything. It means you can practice your religion at your place of religion. It's a gimme. Now, Section 3. Intentionally damages or destroys the property of a facility or attempts to do so because such facility provides reproductive health services. Now here comes the politics. Or intentionally damages or destroys the property of a place of religious worship. The politics in this is clear as day. You see that one side of the aisle argued for this law, and you see that the other side of the aisle became concerned. And so they plopped in random language about religion. It doesn't even fit. It doesn't even flow when you read the statute. Okay, so anyway, Section 3 has some random language about religion that really doesn't fit. And then in Section B, they get into what the alleged penalties could be. And they actually have it defined as the first offense and second offense. And then they get into violent versus nonviolent. They also address civil remedies. Now, this is important, right? Because this means that not only can a person be, quote unquote, arrested and charged criminally under the FACE Act, but also you can have a person who feels that they were harmed under this subsection sue someone under the FACE Act. That can be done as well, right? So that is detailed here, and they detail relief as well. They then discuss that the Attorney General can get involved. So this can rise to a very high level of prosecution. And they go on to discuss how an Attorney General could get involved and the relief therein. They then go on to talk about rules of construction. Now, this is going to be vital. Because remember, we referred to the term intimidation and the term interference as something that can be really subjective. So now let's look to the rules of construction here and see if there's more guidance there. So to prohibit, nothing in this section shall be construed to prohibit any expressive conduct, including peaceful picketing or other peaceful demonstration protected from legal prohibition by the First Amendment. Let's all take a moment. So, if you remember the conversation we had in the beginning of this live about the First Amendment, this law in itself admits that it is subject to your First Amendment. So, if your First Amendment says you have the right to practice your religion, you have the right to assemble with persons that agree with your religious beliefs, and you have the right to do so peacefully, and you're doing so outside of a health center that provides quote unquote reproductive health services, why would you then be arrested? I'm going to leave that question out in the air and open the floor for Mrs. Williams to say anything that she might want to share at this point.
Yes, that's got me thinking a lot. So, in a sense, faith simply becomes powerful, and I'm asking a question. Faith becomes powerful once there is an interference or if there's any violence. But as long as there is no, proven interference and violence. But other than that, if it's just a peaceful protest and it is not proven to block people from getting their services, technically, I don't want to say it becomes null and void, but that's what it kind of sounds like. I mean, I'm simple with law, so you got to break it down to me a little better.
Well, no problem. I'll break it down. So you have to remember the or attempt to. When we talk about these federal criminal laws on my channel, I always tell them you have to be mindful of the attempt to. And you'll notice people are sometimes prosecuted for their attempt to do something, you know? So, yes, FACE focuses on physical obstruction, and FACE focuses on either harming someone physically or physically intimidating someone. But FACE also has that portion of or attempts to. And so, in general, prosecution could prove that someone attempted to cause a physical obstruction, and that could be enough, even if the obstruction wasn't actually successful.
Okay.
Right.
Interesting.
But the attempt has to be there, right? The attempt to physically obstruct, the attempt to intimidate and interfere with in some sort of forceful way has to be there.
Okay.
Yeah, that does have to be there. They then get into the limitation on remedies, right? So they cannot create any new remedies that would interfere with free speech or free exercise. Very ironic of them to say, considering what we've discussed, right? But it says clearly there cannot be an interference with activities that are protected by free speech or free exercise. They literally say that. I'm going to read it for you verbatim. To create new remedies for interference with activities protected by the free speech or free exercise clauses of the First Amendment to the Constitution occurring outside a facility, regardless of the point of view expressed, or to limit any existing legal remedies for such interference. Literally, it says, if you are exercising your religion, you can do so outside of a facility. You can do that. Okay, they then go on to say that there are going to be no exclusive penalties. Okay, and they also say that this shouldn't be in any way construed to interfere with the enforcement of state or local laws regulating the performance of abortions or other reproductive health services. Number 4 is I think colloquially, you all might call it a loophole, right? Because remember, each state is controlling how pregnancy termination occurs in their state. So number 4 is a bit of a loophole, right? New York State could say, well, we have our own, local laws about or local ordinances about this or about that. But again, if those are the things that apply, then charging you in federal court means that they have to bring in all of that local law as well, right? So they would have to specifically address that in the indictment.
I have a quick question.
Yes.
Now, because Roe versus Wade was overturned back to the states, wouldn't that mean faith becomes something of an issue for the states?
Hmm. Very interesting. So, not necessarily faith, right? So, the issue of Roe v. Wade isn't, and this is in the eyes of the law, I say this. In the eyes of the law, the issue of Roe v. Wade isn't connected to faith. It's more so connected to the question. And I actually have a video about this on my channel if you ever, want to check it out one day. But it's connected to the question of when does life begin? So if you look at all of the court cases, the question is, what is life? Is life the minute that the egg and the sperm combine and you have a zygote? Now that's life? Or does life begin when the woman gives birth? That has always been the question. So from a legal perspective, the question is, when does life begin? Because, and we also went into this in my video where I dive into Roe v. Wade, because if legally it is ever decided that life begins in the womb, then abortions are absolutely illegal across the board because you have the constitutional right to life. That's like one of your first, unalienable rights. So if legally it is ever decided that life begins in the womb, abortion would be illegal. But now the flip side is if it is ever legally across the board decided that life does not begin until the woman gives birth, then that would mean that pregnancy termination could occur up until birth. And you can see the variation in the different states. And every variation you see in each state represents when that state decided that life begins. So for example, in the state of New York, and I think I'm right on this, but in the state of New York, I believe a woman can get a late term pregnancy termination. Like she can terminate.
That's right.
Right. Because the state of New York has decided that life does not begin really until you give birth. But then you might go to a different state, such as I think Florida limits it to maybe like your first 12 weeks of pregnancy, something like that, right? So then you might go to a different state and they say, no, we believe that life begins in the second trimester. And then their laws would reflect that.
So I have one more question and then I'm gonna let you go ahead and go. So now what is this thing where when a pregnant woman is murdered, sometimes they're charged for double homicide? Would that still be based off of state?
That is a very, very, very good question. So now you've actually brought up something that is discussed very often in the legal world. So very often there's this concept of whether or not laws have to have continuity or whether or not laws on different topics can have a variation in interpretation, right? That's the conversation. So what Mrs. Williams is talking about is, do laws have to have, or rather, should laws have continuity? So here's the example. Let's go back to New York. If a woman can terminate her pregnancy, like late term, pretty much right up until birth in New York, right? If that is the case, and if a pregnant woman is a victim of a homicide and she is, pretty close to giving birth, should New York be able to prosecute her assailant for 2 lives if New York also says that that baby isn't a life when she wants to terminate? Can they say one thing but then say another? That is a question that there is no answer to, by the way, Mrs. Williams. And it's a debate in the legal world. Do these laws have to have continuity? And I do think in the state of New York that a person who causes the death of a pregnant person can be charged for the death of the embryo as well. So it is an interesting discussion. It's been argued about in the legal world for quite some time.
Okay.
Right. So it is an interesting point. Very, very interesting point. Do the laws have to have some level of continuity in their definition? And as of now, there's no answer. So now we get into definitions. Oh, interesting. So there is some level of definition here for interference and intimidation. So interference, the term interfere with means to restrict a person's freedom of movement. Huh.
Interesting.
Yeah, got more vague.
Okay. Now this is getting good,
More
girl.
vague.
You is the truth. Okay.
That only got even more vague than our initial discussion. So to restrict a person's freedom of movement, well, again, that is subjective. What does that mean? Does that mean if you physically restrain me and I can't move? Or does that mean if you say something to me that makes me feel like I shouldn't move? What qualifies as restricting a person's freedom of movement? Then intimidate. Intimidate is means to place a person in reasonable apprehension of bodily harm to him or herself or to another. Okay, intimidate did something. Interfere with, that only got more vague. But this definition for intimidate does something. So to place a person in reasonable, this is the key, everyone, apprehension of bodily harm to him or herself or to another. So remember, I said, when we look at these laws, I'm doing so from an unbiased perspective, right? And I'm telling you that these laws should have objective terms in them. Whenever you see the use of the term reasonable, that is a good thing because reasonable under the law is an objective term. It's not subjective. It's not, whatever you feel is reasonable. No, no, no. There is an objective standard for what is reasonable and what is not. So here, there's an objective standard. What a reasonable person, what this means pretty much, taking away the legalese. Intimidate means, would a reasonable person think that they are going to be physically hurt? That's what intimidate means. And that definition actually clears some things up. Not like number two. Mrs. Williams, did you have something you wanted to add?
No, I'm blown away. I mean, I have to say for the intimidation part, I feel like that alone could kind of help clear some things up because again, if there is not bodily harm, you can't really accuse of that, right?
Right. And again, there's the reasonable standard. Would a reasonable person feel like they could be harmed? That is the standard. So if a person is totally reasonable, would they feel like, oh my goodness, these protesters are going to, beat me or hurt me or something of that nature?
Okay.
All righty. So I think we're coming down to the end of this here. We have what reproductive health services means. Yep. Okay, then. So I think we've gone through the law, the indictment, and I think we've gotten some clarity on what is occurring in regards to the FACE Act and whether or not it is challenging your First Amendment right. Now, the act itself says that it doesn't challenge your First Amendment right. The act itself says that it's supposed to be subject to your First Amendment right. Now, here's the thing about law, which is why we have to have these conversations and we have to monitor law. Law is only as good as the way that it is used and the way that it is enforced. So it is wonderful that the FACE Act says it's subject to your First Amendment. That's awesome. But now we, the people, we have to make sure that the way it is being applied is in accordance with that. So we have to monitor cases like this. Now we've heard Mrs. Williams' version of events, right? And we've seen the indictment. So we know the chasm between the two. And so we, the people, should be monitoring this case and seeing what actually takes place in court, hearing some accounts of what actually happens here to see if this law is being applied in a manner that is conducive to our First Amendment right. Mrs. Williams, is there anything you'd like to express?
Yes, I just like to tell you that this was amazing and, very insightful for me. I'm actually quite grateful that I was able to be on this interview with you. And, I'm actually interested to hear more about what you have to say about law now, because this is truly intriguing.
Thank you so much for that, Mrs. Williams. As I said, kudos to you, giving you your flowers for standing up for what you believe in. And I want to say that I apply that to anyone who's not harming someone. Okay. If you have a moral conviction and it's in accordance with your religion, I believe that you have the right to practice your religion. It doesn't matter if I agree with your religion or not, or if it's the religion that I like, or none of those things are relevant to your right to practice your religion and be the person that you are. On this channel, we discuss law and I break it down and we talk about, all of these things. And I try to do so in a really, really non-personal matter, although sometimes my personal may seep through. But it is so important. I cannot stress enough how important these conversations are. So thank you everyone who is here tonight. Listen, I know that this is not about, R. Kelly or Brother Polite or Nature Boy or, one of these other like pop culture-y celebrities, right? I know, although I dare say Mrs. Williams is a celebrity in her own right? That's another conversation. But I know that the people who are here tonight are like the people who are truly dedicated, because this isn't one of those clickbaity type of topics. But know that you've been a part of a very important conversation. I hope that you like this video, that you share this video so that this conversation can get out and about. We need to keep our eyes on this case. No matter what side of this issue we are on, we need to monitor this case, because we need to make sure that our right to protest remains. Okay. All of you who get up in arms about when things happen with law enforcement, that's your right to protest, honey. If people are being prosecuted for protesting, then you can't protest against law enforcement either. So everyone, we should keep an eye on these types of cases. And I definitely will be monitoring this. I will open the floor just once more in case Mrs. Williams has anything else she'd like to say. But if not, we're going to wrap it up.
No, that's it. I was grateful to be on here, and I just thank you. And God bless all of you that are listening.
Thank you, Mrs. Williams. We received that, and the same to you and your family. All right, everyone. So thank you for joining me for another installment of, we changed our name, so let me think. The Empowered Esquire podcast. There you go, new name. You bring something to this channel, to the world, to my life that is unique, and I love you for it, right? As I always tell you, not because of what car you drive or what job you have, right? I love you for you. I hope you've been enlightened by the conversation that we had today. I hope you've learned something about the law. You've been empowered with your right to protest, and know that the infringement of First Amendment rights anywhere, as MLK would say, right, is an injustice everywhere. And we have to stay vigilant in things like this. All right. So anywho, I'll see you around. And hopefully I will be live again sometime soon. I can never promise you guys when that's going to happen, because especially holiday season. But I'd love to maybe see you all again. That'll probably be in the new year. All right. So have a wonderful rest of 2022. Look forward to 2023, to health and prosperity, and I will see you then.